Hello friends, Namaskaram. Myself is Dr. Jinesh Soni. I am an advocate and a corporate lawyer. In today's class, we will discuss chapter number 38 of Bharatiya Nagarik Suraksha Sanhita 2023. I request all of you to maintain a proper notebook and also have a bearer of BNSS with you. Directly we are coming on section 513. It merely says, for the purpose of this chapter, unless the context otherwise require, the period of limitation means the period specified in section 514 for taking cognizance of an offence. The said section corresponds to section 467 of CRPC. Now we are coming on section 514 of BNSS. It merely says bar to take cognizance after the lapse of period of limitation. Subclause number 1 says except as otherwise provided in the BNSS. No court shall, it is not may, it is shall. No court shall take cognizance of an offence of the category specified in subsection 2 after the expiry of period of limitation. So we could say that the period of limitation plays an important role in the criminal litigation, and if the period is expired, in that scenario, the court shall not take the cognizance. If cognizance is taken in violation of section 514 of BNSS, in that scenario, proceeding would be vitiated and continuance of the proceeding would be abuse of process, and that's why to quash such proceedings we may approach directly to Honorable High Court as per the protocol of section 528 of BNSS. Please be noted. As far as subclause number 2 is concerned, it simply says the period of limitation shall be 6 months. If the offence is punishable with fine only, it shall be 1 year. If the offence is punishable with imprisonment for a term not exceeding 1 year. But if it exceed 1 year, but never exceed 3 years, in that scenario, the period of limitation would be 3 years. Subclause number 3 merely says, for the purpose of this section, means section 514 of BNSS, the period of limitation in relation to offences. The word offences is used, not offence is used, which may be tried together, means the concerned accused is charged with multiple offences. In that scenario, the period of limitation shall be determined with reference to the offence, which is punishable with the more severe punishment, or as the case may be, the most severe punishment. For example, there are two charges on a person: abetment of suicide and dowry harassment. The period of limitation shall be determined in reference to abetment of suicide. That is section 514 subclause 3 of BNSS. Apart from that, there is an explanation which says that for the purpose of computing the period of limitation, the relevant date shall be the date of filing of complaint as per the protocol of section 223 of BNSS, or the date of recording of information, means FIR, as per the protocol of section 173 of BNSS. Even the said section correspond to section 468 of CRPC 1973. Please be noted. Now we are coming on section 515 and 516 of BNSS. Section 515 of BNSS merely says the period of limitation in relation to an offence shall commence on the date of offence. It is subclause number A. Subclause number B says that where the commission of the offence was not known to the person aggrieved by the offence or to the police official the first day on which such offence comes to the knowledge of such person or to the police official, whichever is earlier. In that scenario, the said date would be the date of offence, and the period of limitation shall commence from that day or date, as far as clause number B is concerned. Clause number C says that where it is not known by whom the offence is committed, the first day on which the identification of the offender is known to the person aggrieved by the offence or to the police official making investigation into the offence, whichever is earlier, shall be the date from which the period of limitation shall commence. So we are having three categories: the scenario where the date is known, the scenario where date is not known, the scenario where the identification of offender is not known. Subclause number 2 says that in computing the period of limitation, the day from which such period is to be computed shall be excluded. So basically, when we are going to work on section 515, subclause 1, subclause B and C, in that scenario, section 515, subclause 2 of B and SS plays an important role. I am going to make it more specific for you. Please read it again. In computing the set period, the date from which such period is to be computed shall be excluded. Means the day on which offence is committed or offence is reported as per clause number B and C is to be excluded. So basically it is giving you a single day margin as evident by the bare reading of clause number 2 of section 515 of BNSS. The said section corresponds to section 469 of CRPC 1973. Now we are coming on section 516 of BNSS. It says exclusion of time in certain cases. It says in computing the period of limitation, the time during which any person has been prosecuting with due diligence another prosecution, whether in a court of first instance or in the court of appeal or revision against the offender, shall be excluded. That is very much important protocol to be noted, and it is not easier to understand the same by having the bare reading of the said protocol. I will explain you the same in certain segments. First of all, we have to note down that in computing the period of limitation. Simple na? Please note down. The time during which any person has been prosecuting with due diligence another prosecution, whether in a court of first instance or in the court of appeal or revision against the offender, it shall be excluded. To make it more specific, we have to understand the said scenario with the help of an example. But before coming on the example, I would like to draw the kind attention of all of you towards the proviso attached with subsection 1. It says that provided that no such exclusions shall be made unless the prosecution relate to the same facts and is prosecuted in good faith in a court which from defect of jurisdiction or other cause like nature is unable to entertain the same. So the proviso is inter alia going to help us to understand the basis of subsection 1. For example, I have to file a case against a person and I had submitted the same in a wrong court, and it is shown that I have done that mistake in good faith and I have taken the due diligence while filing the case, but despite of that mistake was committed. In that scenario, the period of limitation would be excluded, which is inter alia wasted while having such prosecution. And that's why in that scenario we have to file the application as per section 516 subclause 1 of BNSS to claim the exemption or exclusion. Otherwise, on suo motu basis, no remedy could be inclined by the concerned court. And we have to give the specific reasons. If the reasons are not specific, the pleadings are omnibus or general, in that scenario, no remedy could be inclined. Please be noted. Now we are coming on subsection 2. It says that where the institution of the prosecution in respect of an offence has been stayed by an injunction or order, then in computing the period of limitation, the period of continuance of injunction or order, the day on which it was issued or made, the day on which it was withdrawn shall be excluded. So any case is to be filed, but the prosecution in respect of that offence has been stayed by an injunction or order. So in computing the period of limitation, the day on which such order or injunction was passed and the day on which such injunction or order was withdrawn shall be excluded. Please be noted. Subclause number 3 says that where the notice of prosecution for an offence has been given, or where under any law for the time being in force, the previous consent or sanction of central government or any other authority is required for the institution of any prosecution for the offence. In that scenario, in computing the period of limitation, the period of such notice or time required to obtain such consent or sanction shall be excluded, will not be taken into consideration. For example, I have to prosecute a public servant and previous consent is required. In that scenario, the time occurred in taking consent or sanction will be excluded as per the protocol of section 516 subclause 3 of BNSS. But please be noted, to have the benefit of exclusion or exemptions, we have to make an application with specifications and reasons. If the application is general or omnibus or there is no specification, in that scenario, the remedy could not be inclined. Every fact must be supported by some evidences, which must be consistent and corroborating in nature. There is an explanation which says that in computing the time required for obtaining the consent or sanction of government or any other authority, the date on which the application was made for obtaining the consent or sanction and the date of receipt of order of government or authority shall both be excluded. So basically it is going to specify clause number 3 more effectively. The day on which application is made and the day on which consent is given, the time occupied in the said scenario would be excluded, would not be counted. So basically when we are going to study section 516 subclause 3 of BNSS, in that scenario, explanation plays an important role. Subclause number 4 says that in computing the period of limitation, the time during which the offender has been absent from India or from any territory outside India which is under the administration of central government, has avoided arrest by absconding or by concealing himself, it shall be excluded. So in case it is appearing that the accused is absent from India or from any territory, even the outside India, but which is under the administration of central government, or he is going to avoid the arrest by absconding or concealing himself, in that scenario, the period of limitation shall be excluded. But please be noted, the said protocol is beneficial for the police officials because they have to file the police report. But sometimes due to absconding of accused or absent of accused, the problem occurs. In that scenario, if there is a delay in filing of report and the said report is accompanied with an application under section 516 subclause 4 of BNSS, in that scenario, the said period would be excluded. The said section corresponds to section 470 of CRPC. Now we are coming on section 517 of BNSS, that says exclusion of date on which the court is closed. Where the period of limitation expires on a day when the court is closed, the court may take cognizance on the day on which the court reopens. For example, the limitation is going to be shut down on the day of 25th of December. As we know that on that day we are having Christmas, so there is a possibility that the court may be shut down. In that scenario, the case may be filed on the next day so that it could be brought within the period of limitation. And that's why in that scenario, section 517 of BNSS plays an important role. To be noted that there is also an explanation which says a court shall be deemed to be closed on any day within the meaning of this section if during its normal working hour it remains closed on that day. And apart from that, the closing of court may be due to any reason. it might be a public holiday, there might be a demise of a Chief Justice of Supreme Court of India. Because we observed number of cases, even for that scenario, the court remained closed. So, in that scenario, we could take the advantage of Section 517 of BNSS. Section 518 of BNSS says continuing offence. In case of continuing offence, a fresh period of limitation shall begin to run at every moment of the time during which the offence continues. For example, the case of dowry harassment. The said section corresponds to Section 472 of CRPC 1973. And last section of this chapter is Section 519 of BNSS that says extension of period of limitation in certain cases. It says, notwithstanding anything contained in the foregoing provision of this chapter, means chapter number 38, the court may take cognizance of an offence even after expiry of period of limitation, if it is satisfied that concerning the facts and circumstances of the case that delay has been properly explained, or it is sine qua non to do so in the interest of justice. The said section corresponds to Section 473 of CRPC 1973. So basically, in the nutshell, we could say that the court could not take cognizance of an offence after the period of limitation, but it can do so if delay is properly explained. And apart from that, Section 518, Section 517, Section 516, Section 515 are the exception and explanation to Section 514 of BNSS. So I think that I am totally able to cause all of you to understand the basis of chapter number 38 of BNSS. In case you are having any query about the subject, you may leave your comment in the comment box so that I could answer them accordingly. See you in the next video. Till then, Jai Hind, Jai Bharat.